Hello, this is Masterclass from AwaazSouthAsia. I'm Nirupama Subramanian. The topic for discussion today is the Supreme Court's verdict on December 11th, upholding the validity of the government's revocation, or more technically correctly, reading down of Article 370, and thus abolishing the special status of Jammu and Kashmir. Prime Minister Narendra Modi hailed the verdict as historic, one that in its profound wisdom had fortified the very essence of unity that we as Indians hold dear and cherish above all else. But the verdict has also been criticized as a political verdict, as a verdict that undermines Indian federalism. It has been met with anger and disappointment in Jammu and Kashmir, where the political parties have suggested that their struggle will continue. Former Chief Minister Mehbooba Mufti said that this is not the word of God. And former Chief Minister Omar Abdullah has said that that the struggle will continue, although he did not. Neither of them said very clearly what their next step would be. The court order is nearly 500 pages long. It is complex and not very easily understood. Even lawyers are finding it very difficult to actually go through. But for those who are not familiar with the legal nuances, it's even more tough. So my guest today is going to help us do just that. Jinaly Dani is an accomplished lawyer and the Maharashtra head of the Vidhi Centre for Legal Policy. In this role, she interacts with the government of Maharashtra and the several union ministries in their research and drafting of legislation. The reason she's here today, though, is that she's also an acknowledged expert on Article 370. She has co-authored a book called Hamin Ast, a beautiful title, Jinaly. Welcome to Masterclass at AwaazSouthAsia.
Thank you.
To begin with, Jinaly, if I may ask, the judgment has been predictable in some ways, but it has also been unpredictable in many other ways. We'll come to the judgment in a little bit, but can you please, for the benefit of the viewers, briefly explain Article 370?
Sure, Nirupama. Firstly, thank you for having me today. It's a pleasure to speak to you today about the judgment. Like you said, it's a fairly long judgment and fairly complicated as well. So I think it is good that we are starting with a description of Article 370 itself, trying to break it down, because I think only once we understand Article 370 will we be able to understand what happened in August 2019 and then the court's judgment a few days back. So I think to break down Article 370, the first thing that one notices about the provision is that it appears in Part 21 of the Constitution, which is called temporary, transitional, and special provisions. So that's the name of the part, and that's where the article appears. The second thing that one notices about the article is that the marginal note beside the article says temporary provisions with respect to the state of Jammu and Kashmir. So some of these words are important because the court has sort of, looked at them very closely. The court has looked at where the placement of the article was and what the marginal note for the article said. The fact that it said it was temporary, the fact that it said it was transitional, and the fact that it said it was special. So that's the first thing one notices when one opens the Constitution and, tries locating Article 370. Then once you get to Article 370, I think Article 370 has a few important things that it says. The first thing that Article 370 says, I have the article open here in front of me. It says that Article 1 and Article 370 shall apply to the state of Jammu and Kashmir. Now, Article 1 is the first article of the Constitution. It says that India is going to be a union of states and all of the states are listed out in the first schedule. And Jammu and Kashmir, prior to its demotion as a union territory, was listed as a state in the first schedule, which means that Jammu and Kashmir is an inalienable part of India. It is a state of India, and India is formed by all of its states. It's a union of all of its states. The next thing that Article 370 says is that what it does is it principally it limits the jurisdiction of the union over the state of Jammu and Kashmir. And it gives the state of Jammu and Kashmir autonomy on certain matters. Now, that's done by a variety of things under Article 370. Firstly, Article 370 says that the Union Parliament can make laws for Jammu and Kashmir under the Union list and the concurrent list in consultation with the state government of Jammu and Kashmir if matters on which it is making the laws correspond to matters under the instrument of accession that was signed by the Jammu and Kashmir state. So in 1947, October 1947, Maharaja Hari Singh acceded to India and signed an instrument of accession. That instrument of accession ceded a variety of matters to the Union of India, namely they were to do with defense, foreign affairs, and communications. What Article 370 says is that the parliament can make laws for the state of Jammu and Kashmir under the union list and the concurrent list of the constitution if the matters correspond to these matters under the instrument of accession. And if they correspond, then they have to consult with the state government of Jammu and Kashmir. If, however, the matters are outside of the instrument of accession, outside of the matters that were ceded by Maharaja Hari Singh to the Union of India, then the concurrence of the state government would be needed. So that's the first thing Article 370 says. The next thing Article 370 says is that the provisions of the Indian Constitution will apply to the state of Jammu and Kashmir as may be specified by the President. So the President can issue an order and specify the constitutional provisions which will apply to the state of Jammu and Kashmir. Again, if these constitutional provisions relate to the matters under the instrument of accession, consultation with the state government is needed. And if they are outside of the instrument of accession, concurrence is needed. So in both places, there is this consultation concurrence pattern happening, which basically sort of tells us that the union's power over Jammu and Kashmir, their power to sort of make laws for Jammu and Kashmir, and the power of the president to extend the constitutional provisions to Jammu and Kashmir were limited in some manner. They were limited to the matters under the instrument of accession. And lastly, what 370 says is that it provides a mechanism for its abrogation as well as amendment. So 370 subclause 3 says that 370 can cease to operate or it can be modified by the president by way of an order. However, such an order can only be issued upon the recommendation of the Jammu and Kashmir Constituent Assembly. So that's the last important part of 370. So all of this together, once you read 370 together, there are a few things that are very clear to the reader. Firstly, that Jammu and Kashmir is a part of the Indian Union. Article 1 applies to it. It has acceded to India. And like the court rightfully holds a few days back, there is no sovereignty that Jammu and
Internal
Kashmir.
sovereignty is what they called it.
Yes, yes. What they do have, however, is a sense of autonomy under Article 370, which is the autonomy to decide their relationship with the Indian Union. Because the Indian Union cannot make laws for the state of Jammu and Kashmir without either consulting or concurring with the state government. Similarly, they cannot extend the provisions of the Indian Constitution to the state of Jammu and Kashmir without consulting and concurring with the state government. And lastly, the union cannot abrogate or modify 370 without a recommendation from the Jammu and Kashmir Constituent Assembly. So that's what 370 is. It is the coming together of two entities, the Jammu and Kashmir state and the Indian Union, and then sort of negotiating their relationship by way of Article 370.
This is what the court described as asymmetric federalism.
Yes, yes, that this is an aspect of asymmetric federalism. And there are multiple other similar provisions under the Indian Constitution for a variety of different states, that exist. And they sort of give different states different degrees of autonomy in terms of deciding their relationship with the Indian Union. Kashmir is not just, an outlier.
Great. I think that really sets the stage. And I think one more thing that maybe you can do before we move to the judgment itself is to just run us through the events that preceded the abrogation of Article 370 on August 5th, 2019, simply because I think these were points of contention that were raised by the petitioners and which the court then adjudicated on.
So I think it's quite a complicated fact pattern, including, up until August 2019, when the two constitutional orders are sort of issued by the president. The run up to those two constitutional orders is quite complicated. So I'll start by saying that in 2015, the state government was formed between PDP and BJP. And like you mentioned, in 2018, the BJP government withdrew support. The BJP party withdrew support from the government. Ms. Mehbooba Mufti, she was the CM, and she resigned immediately one day later after the government fell and the BJP withdrew support. One day after her resignation, and this is important to note, it was just immediately one day after her resignation, the governor issued a proclamation under Section 92 of the Jammu and Kashmir Constitution and imposed governor's rule. So Jammu and Kashmir, unlike any other state in the Indian Union, has had its own constitution until August 2019. And one of the provisions of the constitution, which is Section 92, provides for governor's rule. And so this provision was invoked one day after Ms. Mufti resigned, and governor's rule was imposed. I'll quickly just take the viewers through what Section 92 says in very brief. So Section 92 actually provides, like I said, for the imposition of a governor's rule in case there is a failure of a constitutional machinery in the state. So what the provision says is that if the government of a state cannot be carried out in accordance with the provisions of this constitution, the governor may, after seeking concurrence from the President of India, impose governor's rule in Kashmir. And I think what is important to note over here is two other things. One is that the rule cannot be more than 6 months from the day it was first issued. And secondly, while the state is under governor's rule, the governor can assume all functions of the governor of the government of the state and vest it in himself. So that's the effect or the consequence of governor's rule. So that's what Section 92 says. It's somewhat similar to the provisions under the Indian Constitution when it comes to president's rule. So this is what happens. So first, we have governor's rule being imposed in 2018 as soon as the CM resigns. Now, this governor's rule, as per Section 92, is supposed to expire within 6 months, which is somewhat December 2018. It's supposed to expire. Before it expires, the governor submits a report to the President of India and recommends the imposition of a precedent's rule under Article 356 of the Indian Constitution. So that is the recommendation made by the governor. Again, I'll just take the viewers quickly through 356. It is very similar to 92, which I just described. So 356 is President's rule under the Indian Constitution, and it is also imposed in case of failure of constitutional machinery in the state. So that is what 356 says. When 356 President's rule is, the President can assume all the functions of the government of the state, and also the Parliament can sort of assume all functions of the state legislature. So that is the consequence of the President's rule. And again, the provision says that the President's rule will cease to operate within a period of 6 months, except 356 allows for an extension of President's rule, which is not present under 92. Yeah. So that is what 356 of the Indian Constitution says. And the report has to come from the governor of the state that constitutional machinery has broken down. And then the president, based on that report, can impose President's rule. So in December 2018 is, when the governor sort of makes that report to the president and recommends the imposition of a President's rule. So President's rule is then imposed in Kashmir, and it is approved by both houses of the parliament. Like I said, while the President's rule is imposed, the functions of the state government and the governor are vested in the president. the functions of the state legislature are vested in the parliament. I also forgot to mention that before this happened, the governor also dissolved the legislative assembly of the
Yes.
state. So there is no legislative assembly in Kashmir at this point of time. And in any case, the functions of the state legislature are now vesting with the parliament. The other thing that this 356 proclamation in December 2018 interestingly does, and I don't think people sort of knew what was happening, at least at that point of time, is that it suspends the first and second proviso of Article 3 of the Indian Constitution. Now, I'll quickly take the viewers through what Article 3 says. I know I'm going back and forth with the articles, but they're equally important. What Article 3 of the Indian Constitution says is that Article 3 allows the Parliament to create new states, to create new UTs, to diminish the area of a state, alter boundaries of a state, change the name of a state, etc. So that's Article 3. Except there are two provisos to Article 3. The first proviso is applicable all across India, and the second proviso is only specific to Kashmir. The first proviso says that no bill for the alteration, diminishing, changing of name, etc., for a state will be introduced in the parliament, except on the recommendation of the president. And also the president has to refer the bill to the state legislature for their views. So you have to get the views of the state legislature before you alter the boundaries of a state or create a new state or change their name. So that's the first proviso to Article 3, and this is suspended under President's rule. And the second proviso to Article 3, which was specific for Jammu and Kashmir, is that no bill for increasing or diminishing the area of the Jammu and Kashmir state shall be introduced without the consent of the state. So that's the second proviso for Jammu and Kashmir, and both these provisos under Article 3 are suspended during the President's rule in December 2018. So that's where we are in December 2018. Again, this President's rule is supposed to expire within a period of 6 months, and so it is extended in June, July 2019. It is extended again by the President. And then what we have is the two constitutional orders in August 2019, which are under challenge in this case. So the first constitutional order is issued on 5th of August 2019, which is Constitutional Order number 272. It is issued under Article 370, subclause 1. And what it does is, it does two important things, this constitutional order. First, it makes all provisions of the Indian Constitution applicable to the state. And secondly, it makes a slight modification to the way Article 367 of the Indian Constitution is applied to the state of Jammu and Kashmir. Article 367 of the Indian Constitution is an interpretation clause. And there is a change made to the interpretation clause, which is 367. And that interpretation clause, modified interpretation clause, is then applied to Jammu and Kashmir. Now, what is the change that is made? The change that is made is that 367 modification says that the reference to the Jammu and Kashmir Constituent Assembly under Article 370 will be read as the Legislative Assembly of the state. Now, this is done by way of an interpretation clause where one body, which is the Jammu and Kashmir Constituent Assembly, it is said that that body will not be read as that body. It will be instead read as a Legislative Assembly of the state. Right. So these are the two things that the first constitutional order does. Now, it is important to note that because the state was under President's rule, and the power was exercised under 370 clause 1D. And if you recollect, when I had explained 370, I had said that the provisions of the Indian Constitution can apply to the state of Jammu and Kashmir based on either a consultation or a concurrence with the state government. Now, because the state is under President's rule, there is no state government. All powers of the state government are actually vested with the President. The President has further delegated those powers to the governor. So effectively, the President is seeking his own consultation / concurrence and issuing 370, issuing the constitutional order under 370 subclause 1D. So there is no other party. The President has sought his own concurrence effectively and applied all provisions of the Indian Constitution to the state and also modified 367. Right. So that's the first part. Then what happens is after this is that uh, so the first constitutional order is issued on the 5th of August 2019, and then you have the second constitutional order which is issued. That order is issued under a different provision of 370. It is 370 subclause 3. And using the powers under 370 subclause 3, the president issues constitutional order number 273, which effectively abrogates 370. I mean, 370 is still today in the books, but it's reads slightly differently. What it says is that all provisions of the Indian Constitution apply to the Jammu and Kashmir state. But in effect, what that order did was that it abrogated 370 and all the provisions of 370. Now, again, if you recollect, 370 could only be abrogated or modified if there was a recommendation that had come from the Jammu and Kashmir Constituent Assembly. 367 modification said Jammu and Kashmir Constituent Assembly will be read as the legislature of the state. There is no legislature of the state because the state is under the president's rule, and all powers of the legislature of the state are with the parliament. So it is actually the parliament recommending the president that 370 be abrogated under 370 subclause 3. Again, there is no representation from the Jammu and Kashmir state. It is the parliament, the union actually recommending to the union again that
Correct.
Please abrogate 370. So that's what happens with the second constitutional order. And that's, I think, 6th August, the very next day of, after the first constitutional order, that we have the second constitutional order. And post these two constitutional orders, there is another significant thing which happens is that the parliament approves the Jammu and Kashmir reorganization bill, under which Jammu and Kashmir, the state of Jammu and Kashmir, is extinguished in some way and bifurcated into two union territories, the Union Territory of Jammu and Kashmir with a legislative assembly, and the Union Territory of Ladakh without a legislative assembly. So that reorganization happens, and that reorganization happens under Article 3. Article 3, first and second provisos are,
Already suspended.
Already suspended. So, technically the government doesn't need to, the parliament doesn't need to ask anyone. Yet what it does is that, I mean, effectively, because there is no state legislature, the parliament itself recommends, assuming powers of the state legislature, recommends the bill or approves the bill for reorganization under Article 3. So, so that's what happens, and reorganization is sort of approved. So I think through these three actions, which is Constitutional Order 272, Constitutional Order 273, and the Reorganization Act, what is happening is that there is no other party on the table. There is no representation from Jammu and Kashmir on the table. There is no representation from the state legislature, the state government. None of that is there because the state is under president's rule. And using a bunch of, legal like gymnastics, etc., the union effectively applies all provisions of the Indian Constitution to the state. It also abrogates 370, and not just abrogates 370, it diminishes the state into a union territory and bifurcates it. So that's the entire factual pattern until August 2019. And what was challenged in this particular case were the two constitutional orders as well as the Reorganization Act. So that's what is under challenge, and that's what the court has sort of ruled on.
So, what are the key points in the judgment?
Yeah, there are three things which are under challenge. One is the two constitutional orders, and of course the reorganization. So let's start with the first constitutional order, which sort of applied all the provisions of the Indian Constitution to the state of Jammu and Kashmir, and also modified 367 in the way it was applying to Jammu and Kashmir. So this order is held to be valid partially. What the court says is that the application of the entire constitution to the Jammu and Kashmir state is valid. And, I think we'll elaborate on the court's reasoning a bit later, but that's the final ruling. However, the 367 modification is held to be invalid. It's held to be unconstitutional. So only a part of that order is sort of held to be valid. The second constitutional order, which is 273, which abrogated 370, is held to be valid because the court says that under Article 370, the president had unilateral powers to abrogate 370. And the recommendation of the Jammu and Kashmir Constituent Assembly under 370 was not binding on the president. And in any case, the assembly had dissolved. So the power that it had under 370 ceased to exist. However, the president's power still existed, and the president could unilaterally abrogate 370. So CO 273 is held to be valid. The reorganization is actually challenged by the petitioners on two grounds. The first is a very substantive ground. Can you diminish a state and make it into a union territory? And on procedural grounds, which is that was the procedure under Article 3 followed. So I think there are two separate things that the court says on this. On the first issue, it actually does not opine. It leaves the question open. So it does not comment on whether a state can be diminished to a union territory under Article 3. So that sort of is left open by the court, which like I will discuss later on, can be problematic. And on the procedural stuff under Article 3, what the court says is that the views of the state legislature under Article 3 are not binding on the parliament. So procedurally, there is no flaw in the manner in which the parliament approved the Reorganization Act. So reorganization is held to be valid in this case. The court, however, does say that elections should be held in Jammu and Kashmir by September 2024, and I think the Union of India has promised that statehood will be restored to Jammu and Kashmir. So they say that we hope that statehood is restored. That's the comment the court makes. The decision to carve out Ladakh as a union territory is upheld. So that's the court's ruling on reorganization. There are also a few findings on the nature of Article 370, etc., whether the state of Jammu and Kashmir had sovereignty. So I think the court's ruling is that 370, like we mentioned right at the beginning, is not a symbol of the state's sovereignty. It is an aspect of the state's asymmetric federalism, where the state had some autonomy in terms of how to decide, in terms of to decide how the India-J&K relationship will sort of shape up. So it is a feature of asymmetric federalism and not a feature of the state sovereignty of state sovereignty. That is one aspect. It also says that 370 was meant to be a temporary provision, not a permanent provision. So all of that is on the nature of 370, what 370 meant. And lastly, interestingly, on the president's rule and the governor's rule, what the court says is that these questions do not merit adjudication because the petitioner's arguments were more to do with the actions taken after president's rule was imposed, as opposed to the validity of the president's rule itself.
It's a little strange that the court said that, because I think the petitioner's argument was that these have to be counted as part of the decision-making process of August 5th, because these were done in order to facilitate what happened on August 5th eventually. So you have to take these into account, is what I think the petitioners were saying. And they were implying mala fide, basically.
Yes.
These were mala fide actions that were taken in order to facilitate what happened on August 5th. And the court did not accept that.
Yes, the court did not accept it. And I think the ruling of the court was that 370, the way it was drafted, the intent behind 370 was constitutional integration of the state of Jammu and Kashmir, which is what eventually happened in August 2019, and which is what has been happening over the years. Since 1950, we've had multiple constitutional orders being issued under 370, where the state has increasingly been integrated into the Union of India, and more constitutional provisions have been made applicable to the state. So the court's argument is that this is not like after 70 years suddenly all provisions of the constitution have been made applicable to Jammu and Kashmir. This was a process that was long. It was ongoing. It has been ongoing for so many years. And what happened in August 2019 was just the final step or the final culmination. So the union has not done anything that is extraordinary. It has not done something which is completely out of the box. It is just taken the final step which is like a culmination of a long-term process. So it says there is, this exercise was not malified. It was in fact the intent behind 370 and the way 370 was drafted was that the state would eventually be completely integrated with the Indian Constitution, and all provisions of the Constitution would apply. And the state's exercise in what the state did, or what the Parliament did in 2019, was not in conflict with the intent behind 370. It was always meant to be this way. So it says, which is why it says it's not malified.
Right. No, I was asking if the petitioners also argued that the proclamations under 92 of the J&K Constitution and 356 the Constitution, they were themselves malified. Was that the petitioner's contention also?
So I think
that the situation did not warrant this,
yes,
that a government had been formed.
Yes. So I think that, the petitioners do argue that post the CM resignation, the governor should have made an attempt to sort of form a government, should have invited other parties to form a government or show strength in the house, which is something that the governor did not do, because I think within one day of the CM's resignation, governor's rule was imposed. And then thereafter, Legislative Assembly was dissolved. The validity of the proclamation itself, I think I partially agree with the courts, is that most of the petitioner arguments were directed towards the abrogation and the actions taken after the proclamation, as opposed to the validity of the proclamation itself. And the exercise of power by the president after the proclamation, the court says it is subject to judicial review. But you must prima facie establish that the exercise was malified, which it doesn't. It says it's not malified in this case. So the ruling is that, the argument is of the petitioner is more towards the actions. So the court rules on the actions. I don't see much analysis by the courts. And frankly, I don't even in the main petitioner arguments, I don't see much that is being said about the proclamation itself.
Right. So these were basically the broad points of the judgment. And can we now move to the concerns that have been expressed over many aspects of this verdict? And for instance, you said that the validity of the constitutional orders 272 has been partially upheld, which is that the process by which the order changed the wording in 373 from Constituent Assembly to Legislative Assembly, that has been held as ultra vires, right? So the criticism is that if the process itself is ultra vires and not valid, can the actions that flow from it be valid?
Is that, the court's ruling on 367, like you said, is that it was ultra vires. The way 370 was amended using 367 was not the way 370 was meant to be amended. 370 could only be amended under 370 itself, which is 370 subclause 3. So indirectly, in a circular manner, 367 was used to amend 370, and the court rightly said that this was invalid. To your question on whether, if the process is invalid, can the outcomes be valid? I think there's an important distinction to be made over here, is that even though 367, the process itself was held invalid, the outcome, which is abrogation, what the court says is it's irrespective of the 367 analysis. Because the court's analysis on 370 subclause 3 is that the president could unilaterally abrogate 370 without any recommendation from the Jammu and Kashmir Constituent Assembly.
But the point is that he did not. And the government conducted itself on the 5th of August and on the 6th of August as if it did require the recommendation of the Constituent Assembly / Legislative Assembly. Therefore, it amended 370 to read as Legislative Assembly. So the way the government conducted itself it did not imagine or know that it had this power, and it went about doing it according to the book.
According to the book, exactly. So the government did not think it had the power. The court, in fact, has now told the government, you did have this power. You had this power irrespective of the Jammu and Kashmir Constituent Assembly. And I think that is a very valid criticism, is that the government thought it needed the Jammu and Kashmir Constituent Assembly to abrogate 370, which is why it used 367 to sort of modify the way that term was interpreted. And it abrogated 370. The court has held that the entire process was invalid. However, you didn't even need the process because you could have unilaterally done it. So
It
I
ends
mean,
up giving more powers to the government,
to the government.
government than the government thought it had.
Exactly. I mean, I would like to point out over here that because the outcomes of 370, at least the abrogation, are so unconditional and irreversible, that I mean, I am trying very hard to imagine what the alternative could have been. I mean, I definitely think that this is a very valid criticism of the ruling, is that the entire process was held to be invalid, but because the outcome was valid, because it could have been done in some other way, the court said, okay, this is all fine. But then this is something that has always been on my mind ever since 2019, the abrogation happened, especially the way it was done, is that could the court have turned back the clock, and put 370 or reinstated 370 the way it was before August 2019? Could reorganization, for example, be like, could it be reversed in some way? And I think everybody knew in 2019, when the abrogation happened, where this judgment was going to move towards, what the direction of this judgment was going to be. Because there was, especially given the fact that it took them 4 years to come out with the judgment, there was no way that the clock could have been reversed, either on ground or even when it came to 370. Like, I don't see an alternative where 370 was reinstated back to its previous position. Because I mean, constitutionally, what would that mean? Would it mean that in the last 4 years, all of the provisions of the Indian Constitution that have been made applicable to Jammu and Kashmir, all of the laws that have been made applicable to Jammu and Kashmir, would that be reversed? But
it was important for the court to make the point about 367, because then they say that,
yes,
if this is done, if 367 itself is going to be amended to change some other provision in the Constitution, then it could lead to
exactly.
it could be a very dangerous thing.
Exactly.
So they felt it was necessary to draw the red line around 367, but uphold what the government had done, because it did not see itself reversing the clock on what had happened to 370.
Yes. I mean, like I said, the death knell on Article 370 was already made in August 2019, and had 370, only 371D been used, for example, the first constitutional order, had we only, had the government only stopped at the first constitutional order, which is 272, and made all provisions of the Constitution applicable to Jammu and Kashmir, an argument could have been made that you could modify that constitutional order and reverse that change. There is still an argument to be made, an academic argument to be made over there, that you could reverse the changes made under the first constitutional order because they were exercised under 371D. However, usage of 370 clause 3 to completely change the text of Article 370 and wipe out everything that was there in 370, like the court says, it's an irreversible change, unlike the change under 371D. So the outcomes of both 371D and 370 subclause 3, the constitutional orders are just the same, except 370 subclause 3 usage is irreversible. It cannot be changed.
You mentioned the word irreversible. The other point that was made by the petitioners, and that is also being asked as a point of criticism of the verdict, is that under president's rule, can you actually take irreversible actions in relation to any state, because president's rule is for a limited period of time. And can you take actions that are that cannot be reversed, that are permanent in a sense, when the state does not have a legislature? But when it is envisaged that elections will be held after a period of time when president's rule is done with.
Understood. So I think over here, my opinion is that the court takes a very textual sort of interpretation of 356 and 357, which is that it says that the powers of the president under 356 and 357 are, and the limitations on those powers are specified in those articles. To read anything more to it, would be sort of stepping on in the shoes of the legislature, would be sort of like overstepping the boundaries of the judiciary. And I think it's a very legitimate argument that the petitioners make, is that they make two arguments over there. I think even the second argument is quite interesting. The first argument, which you rightly said, is that the idea behind an emergency is behind a precedent's rule is to sort of the situation is that there is a constitutional breakdown in the state and you impose precedent's rule. Any actions that you take under the precedent's rule should be to remedy the breakdown of constitutional machinery. It cannot be an irreversible change that, for example, changes the very boundaries of the state, changes the structure of the state, converts it into a union territory. It cannot be an irreversible change like that. And I think it's a very legitimate argument to be made. The second argument that the petitioners also make is that under Article 356, when the parliament, assumes the role of the state legislature, it can only exercise legislative functions. Only legislative powers are assumed. Constituent powers cannot be assumed. And under Article 370, the powers that were granted to the state of Jammu and Kashmir, both to the state government as well as to the Jammu and Kashmir Constituent Assembly, are constituent powers. They are not legislative powers. So these powers cannot be assumed by the parliament under 370. And I think both these arguments are rejected by the court, because I think the court, like I said, looks at 356, looks at 357, which is the next article, and says that the restrictions on the president's powers are very clearly identified under these two provisions. And we cannot read anything additional. We can't. So, for example, there is no distinction between constituent powers and legislative powers under 356. So we cannot read that distinction when there is no distinction that exists under the article. And as long as there is a justification to be made that the actions taken by the president or the parliament were to further the objective of the proclamation, we are fine. And, we can't comment on the nature of powers that were exercised or what the outcome of the power was. Was the change irreversible or not? Because then what you're doing is, there is a danger that you are going to comment on each and every action that the president or the parliament is going to take under 356. And that is something that we can't do, because at least the court says that under emergency rules, there may be under president's rule, there may be multiple decisions that may be taken by the parliament as well as the president. And a lot of executive decisions may be taken on a day-to-day basis, and we cannot sit in judgment over all of those decisions.
But is that also, that too has come in for some criticism, saying if somebody finds something problematic with a decision of the president or of the parliament, it has all, that person or or that entity has all rights to go to a court and say that, look, this is problematic, and why should the court not take up that petition? Why should the court already say that no, there are so many actions are taken, and we can't sit in judgment about all these actions? The court has already seems to have decided that they can't rule over so many things that the government does.
Understood.
under
I
President
think,
Zia.
now that you asked me this question, I have an interesting observation that it came to my mind, especially given the previous discussion that we were having, is that when it came to 370 or abrogation, the court focused on the outcome and not the exercise. It said the way the power was exercised was invalid. However, the outcome was okay. It was valid because the president could have, in any case, unilaterally abrogated 370. So we can't turn back the clock, and it is what it is. And my understanding of the court's analysis, at least under 356, 357, is that it's a very textual and a very, limited interpretation of the way the power can be exercised under those two provisions. So the focus then is on the process, and not the outcome of the process, which is that it's an irreversible change. So it's sort of like conflicting in some way, where under one issue, they are more concerned with the outcome, and the process, even though invalid, it doesn't matter.
Hmm.
uh, as opposed to over here, where they are more concerned with the exercise of power and the limitations on the power, to say they are the limitations of the power under 356 are very clear. There is no distinction between legislative and constituent power, so the exercise of the power was completely valid. We cannot focus on the outcomes, because if we focus on the outcomes, we will be sitting in judgment over every decision.
Correct.
So it seems like, and this is something that just occurred to me, interestingly, when you asked that question, that there are two separate focuses for both of these issues that are happening.
One major criticism is that, um, you know, the parliament could not have taken the decision to downgrade or extinguish the state itself, and decide to downgrade it into two union territories. That it did not have that power. How do you see that?
Yeah, I think before I answer that question, I just like to for the viewers, sort of distinguish, between like a state and a union territory. I know it's very common, like people mostly know the difference, but I think it's very important to like sort of articulate and reiterate why a state is different from a union territory. So states are governed by their own governments, and these governments are directly accountable to the citizens. So you have an elected machinery that is responsible for a state, whereas union territories are centrally administered by the union government. The court actually has, like, the judgment has, it's quite detailed, the way they sort of distinguish and sort of chart out the difference between a state and a union territory, right from 1956, when the State Reorganization Commission was submitted its report, and we had state reorganization. What the court says, and the committee report also said in 1956, and I'd like to reiterate over here, is that states are considered to be financially and administratively viable units, as opposed to union territories, which are created for very strategic reasons, for sometimes perhaps for security reasons. And the idea behind a union territory is also that at some point it will get converted into a state, and that is what has happened in Indian history. Since 1956 until 2019, there has not been a single instance where a state was converted into a union territory. You have created new states, you have bifurcated states, you have promoted or whatever converted a union territory into a state, but never has a state, a full-fledged state, been converted into a union territory until 2019. And that is, I think it speaks a lot for the idea of federalism, because states are federal units. They are an important aspect of the Indian Constitution. They are autonomous. State legislatures, like I said, are accountable directly to the people. State legislatures have powers to make laws under the state list of the Union Constitution, under the Indian Constitution. So states are an important aspect of Indian federalism. Their autonomy is important, their creation is important. Diminishing states to a union territory, usually it's something that is unprecedented, has not happened since 2019. And I would say it is, giving more power to the union. It is sort of, diminishing the idea of federalism in some way, where you are reducing a federal unit and getting it under union control. mean, I think essentially that's what has happened, and that's where the problem lies in 2019, is that it was unprecedented. This was never done, and also the manner in which it was done. So the petitioners, like I said, challenged it on two grounds. One was the substantive ground, that can you, under Article 3, diminish a state, extinguish a state completely, and convert it into a union territory and bring it under union control? And secondly, can you do it in the manner in which you did it, which is the state was under precedence rule? And I think on both fronts, I mean, or at least on the first issue, the ruling of the court, or rather the lack of the ruling of the court, is very, very significant. And I would say, I mean, it is a missed opportunity. It is unfortunate that there was no comment that was made on that aspect, at least on the
The court
procedural
did
front.
not make a comment.
Yes,
Yeah.
yes, yes. The court did
They
not
said
make
that they would not go into it and that they
yes,
would leave it for an appropriate
yes,
situation to
appropriate case
arise.
in the future, to sort of decide this question. And I think, this is something that is a huge gap, and it's sort of, like I said, unfortunate that there is no ruling on this aspect at all, because it is a very important aspect, and it sort of sets a very dangerous precedent for the future. Because what it's potentially telling a state is that tomorrow any state can be under precedence rule. And you can completely disregard the views of the state legislature, the elected state legislature, and alter the boundaries of a state, or change its name, or bifurcate it, or bring it under union control. So so that's a sort of dangerous precedent to have. And I know, like, the question is still open. The court has not said this is okay. But this was actually a great opportunity to comment on something like this.
So was it right for the court to take the word of the Solicitor General that this is going to be, statehood is going to be restored? And therefore, because the Solicitor General has said it, therefore we are sanguine that it will happen, and we say that it should be restored as early as possible, and elections should be held in Jammu and Kashmir under the reorganization provisions by September 2024. I think this is the sum of what they said about it.
Yes.
So can the Solicitor General actually make a promise on behalf of Parliament?
I mean, the Solicitor General at the end of the day is representing the Union of India, and we have to take his word for it when he says that statehood will be restored. He is, of course, authorized to represent the Union on these matters and comment and perhaps promise as well. I think, I mean, what I can comment is at least, like, the court's ruling on it, in which like I said, is that, I mean, I think it was a huge opportunity to comment on something like this, which is, like I said, going to set a precedent in the future. It is a dangerous precedent to set in the future. And the court refusing to do it, and instead accepting a promise made by the Solicitor General, and based on that promise saying that, we do not need to decide or adjudicate on this question, is something that I personally think should not have been the case. They should have opined, on the reorganization under Article 3, because substantively, I mean, this is without precedent. It has never been done before. And also the manner in which it was done is also problematic. All of that should have been taken into consideration by the court, and they should have opined on it. And it's a very small analysis. I don't even think there is any analysis that has gone into it. And leaving it for the future is,
Problematic.
I mean, problematic. Why not do it right now?
Leaving it because if there was an appropriate case, this was it, as many have pointed out. I mean, there could not have been a more appropriate case. And there will never be.
Yes, leaving it for the future means you're leaving the option, or like the window open, that this will be repeated again. And, you are anticipating perhaps that this is going to be repeated again. And when it comes to you is when you will perhaps decide on something like this. I mean, that's like it's a strange thing to say, I would think.
So, all things considered, what is your wrap on this judgment? Because you have said that this part of it is extremely problematic. We've also discussed how the court came at outcomes and processes in a contradictory way in two different situations. Um, so, what do you make of this judgment? In sum,
Yeah, I think my first observation is that the court's ruling on Article 370, what it meant, temporary, permanent, what it signified, etc. Although the ruling does say it charts out the entire history and it says we are interpreting Article 370, given its historical context. I don't think the entire historical context has been laid down, when it came to Article 370.
you have yourself argued in a newspaper article that it was a compact between
Yes, yes, yes,
between India and Jammu and Kashmir.
yes, yes.
So, could you elaborate on that?
Yes, yes. So, like I said, and this is something that is there in our book as well, Hamin Ast. So that book actually, for example, charts the history of Article 370, the constitutional history of Article 370, right from its drafting stage in 1947 until its abrogation in 2019. And if you look at the history, if you look at the circumstances in which Jammu and Kashmir acceded to India, you know, um, i- right from the beginning, the policy of the union government was that the will of the people would be taken into consideration, and this is evident right from the first letter that the Governor General then Mountbatten shoots to Maharaja Hari Singh when he accedes to India. So Mountbatten's letter, says that it's the policy of the government that in any state where accession is disputed, a reference to the people would be made for a final decision. That's the first time you even find a mention of a reference to the people. Subsequently, over the years, India makes promises of a plebiscite at the union, at the UN, it makes a promise, and these statements count towards something. If international statements made by leaders, political leaders, that we will do a plebiscite, even domestically statements are made to the extent that even when Mr. Gopalaswamy Iyengar is introducing the draft of the article, before the Constituent Assembly, he says that the Indian government has made a commitment to the people of India, to the people of Jammu and Kashmir, that their opinion will be taken into consideration before we decide the final India and J&K relationship. That they will take a call on how this relationship is going to be formed. Um, Now, of course, one can argue that a plebiscite was completely impossible. It's impossible today, and it was impossible even then, given the conflict with Pakistan, given the fact that a huge part of the state, was not even, it was controlled by Pakistan. Pakistan occupied Kashmir. It was not even within Indian control. So I think even at that point of time, it was very clear for both India, people at the UN. I think everybody sort of knew, and this is sort of documented in letters as well, etc. Personally, Nehru also admits that a plebiscite was never possible. It was just out of question. And I think all questions of a plebiscite, etc., go down the drain once you have the Maharaja acceding. You also have the Maharaja ratifying the Indian Constitution. You have Article 370, which says, Article 1 applies to Article 1 applies to Jammu and Kashmir. So Jammu and Kashmir is an inalienable part of India. Even the Jammu and Kashmir Constitution admits that Jammu and Kashmir is a part of India. So all questions of sovereignty, all questions of a plebiscite, all questions of a referendum, I mean, they are moot. They are not going to work out within the framework of the Indian Constitution. That was very clear. Jammu and Kashmir is a part of India. Um, However, this concept of the will of the people is somehow reflected in Article 370. Because Article 370 says that, yes, you are a part of the Indian Union. However, the manner in which, the union will exercise power over the state of Jammu and Kashmir will be decided by the people themselves, either in the form of the Jammu and Kashmir Constituent Assembly or the state government. So there were these two bodies that were representing the will of the people, you know, under Article 370. So that will is manifested in Article 370 in some way, and which is why we argue that it was a compact. It was a promise between two different entities. It was a promise in some way by the people of India to the people of Jammu and Kashmir, both represented by different bodies, that we will take your opinion, we will take your will into consideration before we apply any of our laws to you, before we apply the Indian Constitution to you, before we abrogate 370. And this is the spirit of Article 370. This is the historical context of Article 370, which I feel like, it's not been, adequately sort of spoken about in the judgment. The abrogation in 2019, only involved one party. I mean, 370 required two hands to clap. It required both parties to come on the table and comment on 370, either for its abrogation or its modification. August 2019, only one hand clapped. The second hand was not there, And what is even more interesting is that 370, not just the fact that 370 as a promise was nullified in August 2019, but also one of the parties to that compact, one of the parties to that promise, which is Jammu and Kashmir, was fundamentally and unilaterally changed, and converted into a union territory. So one of the parties to the compact no longer exists today. You have nullified the compact unilaterally, and I think that's my opinion, is that, that 370 interpretation was not, my interpretation of 370, given its historical context and my research, is different. And I think it was a compact which required two people to come on the board. That's the first thought I have. And I think the second thought, which I've adequately spoken about right now, is this reorganization of the state and its conversion into a union territory, under Article 3 is a dangerous precedent for the future. And it is also, it is a potential threat to the federal structure of the Constitution and the federal structure of the Republic. I know the question remains undecided, but I feel like this was a great opportunity where they could have decided on this question and closed this matter. And we should not have left it for the future. So I think those are the two sort of thoughts I have on the judgment.
And lastly, I'll ask you about Justice Sanjay Kaul's epilogue, in which he very eloquently and in a very heartfelt way makes this makes this appeal for a truth and reconciliation process to be set up in Kashmir. What do you think of that?
Yeah, I think, like, my only thought on this is that it's a noble thought. Of course, truth and reconciliation commissions have worked, although in different degrees across the world. And something like this, like he also points out, people have been demanding it in Kashmir for a very long time, given the situation in Kashmir. My only thought is, while the thought is noble, you know, unless and until we are sort of clear on how this commission would look like, what the composition of this commission would be, what its mandate would be, and most importantly, what its powers would be, it's really like an academic discussion, right now. I mean, for example, he says that, it should be done in a time bound manner. There's no clarity on when this would be done, what this commission would look like, what its mandate would be, what its powers would be. Because honestly, a commission like this, given the international experience, we understand that, like, there are challenges to a process like this. And one of the very important, like, challenges, that if people don't come forward or are unwilling to participate in a process like this, not just common citizens but also state players, if you don't have, like, state players willingly participating in a process like this, if people do not come forward and narrate their stories, if there is a sense of mistrust, fear, when it comes to this commission or the way it's constituted or its authority, etc., then this process is bound to fail.
And the very last question is about a review. Can somebody go in appeal against this, or can they file a review petition against this verdict? Is that
Yes.
technically possible, or
Yeah.
and is it feasible?
Yeah. So I think on this, there's enough judicial precedent to say that, what the grounds of review should be. And usually a review petition is filed when there is like, something that's absolutely significantly wrong in the judgment. I think one of the examples is if a statutory provision has not been brought to the attention of the court, or like a significant fact has been missed out, or some very patent injustice has been done, like then the court comes in and sort of like, accepts a review petition. But a review petition is not an appeal. you know uh, it can't be that you're unhappy with a part of the judgment and you sort of file a review petition. You can't file an appeal in the garb of a review petition. So my understanding is that review petitions, can be filed on very specific, very limited grounds. It is not an appeal. It is not a chance for the court to rehear the matter and reopen some of the questions that it has already looked at. Or decided, for example, not to comment on. In this case, reorganization, they said we leave the question open. It is not a petition for you to ask the court to rehear the matter or reopen some of the questions that it has already commented upon. So I think, there are judicial precedents to say that something like this, on a matter like this, a review petition, I mean, I find it difficult.
Thank you so much, Jinaly Dani,
Thank you.
for
Thank you.
being with us today, for all your time. This was a very enlightening discussion. Thank you, viewers. If you like this program, please press on the subscribe button. Follow us also on AwaazSouthAsia.com.